this sign-up sheet, we need this. You can sign up with this pen, but don't steal this pen. I like it. But anyways, enjoy the talk.
Thank you. All right, I'm Will Wilkins, and they're recording. They want to record, so I have to kind of stay around here. If that bugs y'all, move on down. Won't bug me. Let me take a poll quickly, though, just to see how many folks are in either of my IP classes right now. Okay, so a number. I'll try not to. There'll be some repeat, of course, but try not to belabor it too long on that. And then a plug for next semester. 2 more IP classes offering next semester copyright. Being one, which is important in a lot of businesses as well, particularly startups, dealing with software, and then also teaching a paper class on emerging issues in intellectual property law. So really, that course will be what you make of it. So if you're interested in doing, need a paper class, it's a 2-hour paper class. Please check that out. I think there's a limit on that class. If you sign up early. What I'm going to talk to you about today, excuse me, if I can talk, is intellectual property, primarily trademarks, and starting up a business. When I was asked to do this, I was thinking about business issues. And my background is initially as a litigator, later as a business attorney, practicing for about 10 years in the area. And it's really how I got into intellectual property. Was number one, I was the youngest guy in my firm, and so anything involving intellectual property for some reason came up, all the old guys would say, "Oh, Will, you do it." I don't know. At the time, I thought that was a great honor. In retrospect, it may be because they just didn't want to do it. So the way I really got into what I do now, which is all intellectual property work, was in working with small businesses. What I do now, when I'm not teaching full time, is I work with a department of the law school called Mississippi Law Research Institute, and we do a lot of different things. One of the things that we do, and we have internships available, by the way, through the public law internship program, if you're interested in that. One of the things that I and one other person in my office do is that we help all the universities in the state with intellectual property matters. And so we're kind of floating attorneys. We don't actually represent any of the schools, but we're there if the attorneys at those schools need us for help in intellectual property. So we spend a lot of time, it's all I do now when I'm not teaching, is practice intellectual property. And I would say of that, I mean, it obviously depends on the time and what's going on at schools, but probably 60% of that is trademark related work. And when I was in practice of the intellectual property work, I did probably 70 or 80% of that work, of the intellectual property work, was trademark work. So I thought in talking to you about business issues and working with clients, because when you go out to practice, you'll get a lot of small clients coming and saying, thinking about starting up a business, that intellectual property issues are important. Trademark issues are real important, but we also have to keep them in perspective. It's easy for me to say this is all you should be thinking about, because it is all I think about. But first of all, notice and recognize that there are other issues when you're dealing with a small startup or any business that are more important. I'll give you some in dealing with like angel investors. When you're talking to angel investors about coming in and helping a startup, they're 90% interested in the management team of the business. So to them, even if it's an IP, a tech type startup, only 10% of their interest involves the intellectual property. I think that's a misconception of a lot of people. I think most people say, gosh, if we get a great patent from the university, we license it out, we can do this startup. The investors, the angel investors and folks like that are primarily interested in the management structure. They're interested in the actual people that are working on it, because you can have a great patent and not be able to do anything with it, not have the management structure to do it. So you do have to keep it in perspective. The intellectual property is a big component of starting a business, but it is just one component. For just a second, let's talk about a couple of those other components, which you probably get through some of your business law classes as well. First, of course, is management structure. The second, which is tied into that, would be entity choice. So you have somebody come and say, look, I've got a great patent I'm going to license from a university. I'm going to start a business. First thing you need to really talk with them about is entity choice. So you're going to be an LLC, are you going to be a corporation? Is it going to be an S Corp? Is it going to be a C Corp? Those are big issues for the company, and really some of the initial issues you should get to, which is also tied real heavily in with tax considerations. And so those are issues that you need to be considering right at the outset. Then you get to the property issues, in my opinion. You get to physical property issues. Are you going to lease space? Are you going to own land? Do you need to own cars? Do you need to own all of this stuff? Because a lot of liability issues go along with that. But hand in hand with that, with physical property, I think comes the intellectual property of the company. At the outset, of course, if it's a tech startup, like I've been using as an example, you're going to look at patents and issues like that. But for any company, trademarks are a big deal. And I'm sorry I don't have any overheads today. I'd show you some examples of trademarks, but we'll talk about a few. You've actually got some examples in front of you that I'll use. One of the first things you're going to talk with the company about, including the management structure and stuff like that, is trademarks. Trademark it defines the business. It defines the services and the goods that a business offers. They can be very, very important. Anybody drink Gatorade? Yeah, everybody drinks Gatorade. Gatorade's a sugary water with a little salt in it, right? It's really all it is. It's got some sodium chloride. It's sugar water with salt. What's really important is the trademark. What is really important is the trademark Gatorade. In fact, it's one of the highest grossing pieces of intellectual property for any university. Gatorade and Google are the two, I think it's still currently the two highest grossing pieces of intellectual property for a university. Now, the Gatorade formula is not a secret. It's pretty easy to make Gatorade if you want to make your own Gatorade. It's the trademark that's valuable there, and it's been very valuable to the University of Florida. So next time you go buy it, if you're not a University of Florida fan, think about it. So it's very important in creating the business to also begin thinking through initially the trademarks and the business names. Now, let me define trademarks before we go any further. Trademark is a name, word, symbol, some type of a device like that identifies a service or good offered by a business. It doesn't have to be a business, but a service or goods. It distinguishes that service or goods, service or product, from somebody else's. Gatorade's a good example. Coke, you've got a Coke bottle. Coke's a good one. Dr. Pepper. Dr. Pepper is another one. Now, notice I didn't say it's a business name. It's not a business name. They can go hand in hand. Dr. Pepper is not made by Dr. Pepper Company. I think it's made by the Coca-Cola Company or somebody like that, or Pepsi or whoever it's made by. Diet Coke is the name of the product, not the name of the company. Generally speaking, a company's name is not a trademark. Now, you get some spillover, obviously, where you get some business names that also serve as their trade or service mark, but they don't have to. The service marks and trademarks, when I use the term interchangeably, a service mark identifies a service that somebody's offering. Ole Miss is registered the phrase Ole Miss is registered as a service mark because primarily what we offer at Ole Miss is a service. Coca-Cola, Diet Coke would be registered as a trademark because primarily what they offer is a product. There's not much distinction between trademarks and service marks anymore at law. But so if I use the terms interchangeably, that's why, because there's not just a whole lot of difference. So we've defined trademarks. It's almost easier sometimes to define something by what it's not. And trademarks, service marks, and copyrights get confused a lot of times. And the reason is because we're talking about two different bodies of the law. When we talk about trademark law and we talk about copyright law, and they can cover the same thing. So, for instance, if I'm going to draw, I'm a horrible. I should even try. All right, so I've drawn a kind of a stylized word mark for Coke, and I'm the Coca-Cola Company, and we like that. I can register that as a trademark, but I've also got a copyright in the design. There's a design there. There's some element of creativity there that's also susceptible to copyright protection. So when somebody starts using that mark or the script Ole Miss, has anybody got a script Ole Miss? I don't see anybody. You know the script Ole Miss that's written in the cursive letters. That's a trademark, but it's also protected by copyright law. So understand that copyright protects the designs, the way something looks, the way something sounds, if it's for music and stuff like that. But a trademark protects, it can be also a stylized design like that is as well. But there's overlap in the law. But trademark protects words, phrase, symbols, and designs that identify goods or services. Now, some trademarks are stronger than others. And it's something that you talk about with the client when they come in and start talking, all right, well, let's talk about your product names. Ad agencies are good at doing this. PR agencies are good at doing this as well. But let's talk about the strength. The strongest trademark that we can have is a fanciful trademark. It's one that makes no sense at all. Anybody think of an example? Somebody in one of my classes can think of one. Yes?
The doctor series, like that series radio.
The what? Sorry, I caught you while you're eating.
Yeah.
Yeah.
Before Sirius and XM merged, Sirius's logo was a dog,
Right.
which is supposed to be about Sirius the dog star, and it's thinking. But when you think about satellite radio, it doesn't really make any sense.
Good. All right. So the example is Sirius the dog for Sirius Radio. It doesn't make sense. That may be an arbitrary. The different levels of trademarks that we would give usually would be fanciful, arbitrary, suggestive, descriptive. Sorry, not good writing on the board either. And generic. So the example given for the dog used for Sirius Radio, if you're selling dogs and you use the dog logo, it wouldn't necessarily be arbitrary or suggestive. It might even be descriptive at that point. There's another great example, Apple. If you're selling apples, it's not a great trademark, right? If you're selling computers, it's a pretty good trademark. Fanciful names are things like Xerox. Xerox, before the Xerox company used it, it doesn't mean anything. It's not in a dictionary. It's a totally made up word. That's a very, very strong trademark. So when you have clients that come in and start talking to you about trademarks and all, that's one thing you can help with. You can talk to them about, all right, well, let's talk about it. Let's talk about the strength of the trademark. And you can explain to them the different categories of marks, suggestive marks, arbitrary marks, and fanciful marks. Again, Apple used to sell Apple, probably descriptive. Apple used to sell computers, it's at least up here at arbitrary. You notice I drew lines but here with descriptive and generic. You can trademark descriptive terms if they attain something that we call secondary meaning. It moves them up into this class of protectable. If it's a generic word, it's never protectable. Bicycle, for my bicycle company, not going to ever be protectable. It's generic. It actually identifies the type of goods rather than the specific goods. So those things are generic. We have to be very careful, and we're going to talk about it in a minute, about protecting trademarks. We have to be very careful because one of these words can actually move down in here into the generic category. So after the company is up and going, and initially even, you should talk to them about that, about protecting their trademarks, and we'll talk about that in a second. Xerox is a great example. When I was a kid in the 70s and 80s, people would say, I need to go make a Xerox. Does anybody still say that? I still say it. So Xerox had this great trademark, really strong trademark, but they had the potential of it becoming generic because it's becoming an action. It's becoming a verb rather than an identifier, a noun, rather than an identifier of their product. So they have to protect it. If it becomes generic, anybody can use it. They can't protect it anymore. So Xerox, Kleenex are the two big examples people use of marks that almost became generic, and they would lose those marks. And I'm going to tell you, we'll talk in a second about how to protect that when you start working with clients on protecting it. But in terms of choosing marks, we always look at those categories and try to help clients choose marks that are in one of the top levels of the trademark categories because it will help us in the long run. Protection. Where does the protection come from for trademarks? We have many sources. It's part of what the folks in my class probably know. We've just finished talking about trademarks. It's part of what makes trademark law and studying trademark law kind of difficult because we have various sources of trademark law. We have state common law that's been around for a long time. State common law has protected trademark basically under the doctrines of unfair competition, unfair trade practices, deceptive advertising, things like that has protected it and say, gosh, when a company like Coca-Cola develops a trademark or develops a unique identifier for their product, we don't want Pepsi now marking their goods Coke because it's going to confuse people. It's going to be deceptive advertising. So we have a lot of state laws like that, and it varies from state to state, the strength and the application of the laws. But we have a lot of state laws that will cover trademarks in that way. We also have federal laws. The primary federal law that protects trademarks is the Lanham Act. Under the Lanham Act, we protect both registered and unregistered trademarks. Huge advantages to registration. We'll talk about registration in a second. So we really have several different categories. We have state court, we have state court, we have state protection, and we have federal protection for trademarks. The best protection really available is if we register it under federal law, under the Lanham Act, if we actually go through the process of filing a registration. It gives us a couple of things. It gives us a national territory, and it gives us priority. It can immediately gain us priority in terms of use of the trademarks. Trademark rights are gained through use. We have the clients I've worked with all the time choose not to register a trademark and think, well, I was the first to use the mark. Consumers associate the product with me. Therefore, I have superior rights in it. And that's true. Registration can mess that up to some extent. And so we want to make sure to register for most clients. There are for a lot of clients when it's merited. It's not always merited. If you've got a client that's doing a special promotion and it's going to last for 6 months, it may not be worth the trouble of registering a trademark. But it's also often very, very helpful. All right, so protections, federal law, state law. Why do we want to protect trademarks? Any questions kind of about trademarks, about what a trademark is? Let me give you some examples, some more examples. Coke, Coca-Cola, McDonald's Incorporated, not a trademark, that's the name of a business. McDonald's Hamburgers is a trademark. McDonald's Big Mac would be a trademark. There's some weird things that can be trademarked. You can trademark sounds. The Hanna-Barbera company at one point tried to protect the beep beep of the Roadrunner. I don't know if they were successful. Harley-Davidson actually tried to protect the sound of their motorcycle as a unique identifier, that when you hear that sound, you know it's a you know for a fact that it's a Harley-Davidson. I don't believe that one was successful because it sounds like any other motorcycle without a muffler. But so you get into some odd things of registration. Some of the current trends in terms of protecting trademarks kind of get over into something we call trade dress, which is kind of the way a business looks. It's an odd area of trademark law. McDonald's Hamburgers would be a great example. If I took all the signage off of a McDonald's restaurant, you'd know what it was, right? That's called trade dress because of the colors they use, the designs they use. What about a Starbucks? If I took all the signs off of Starbucks, that's probably a better example these days. If I took all the signs off of Starbucks, you'd probably know what it was when you walked in without seeing a sign, because the Starbucks and some of those other companies would claim that they have a unique design, and trademark law has to some extent extended to some unique areas like that. Typically colors aren't protectable unless they've attained secondary meaning, but at times we can protect trademarks. But usually when we're talking with startup businesses, what we're talking about are names, words, symbols, designs, things like that. Why do we need to, yeah, question?
When businesses buy and sell one another, I'm sure it's important in the deal that they get the trademarks to whatever the target company is.
Yes.
Is there a secondary market for trademarks? Are there firms or funds that just invest in trademarks?
You know, I don't know of any. It's a good question. Yeah, in any kind of business transaction, I used to do a good bit of business transaction work. In any kind of business transaction, it's critical that we've thought about whether or not trademarks are being transferred. With the transfer, we can, you transfer to some extent goodwill from the other business. So it's a big part of any business transaction that you consider trademark transfers. I don't know of companies that specialize. Part of the thing with trademarks is you have to use them. If you quit using them for a period of, I think the statutory period is somewhere between 18 months and 3 years now. If you quit using them, they'll consider them abandoned. So if the trademark is parked in a secondary market and it's not being used, it will actually be considered abandoned at some point. But I don't know. I don't know if there are companies that actually have set up means of selling trademarks on a secondary market. There are companies certainly that have set up markets for selling domain names and things like that on a secondary market, and we can talk about that a little bit if y'all want to. Any other questions? Just kind of about what a trademark is and stuff.
I have a quick question.
Sure.
I was approached about a year or so ago with the business idea of with an e-commerce website called Bagcore, and so the product is actually in the name. Of course, it's a little bit of shots or consonants with the actual name, but the pairing of those two words implicating a woman that's addicted to handbags. So does that go from being generic to something else when it actually has the product?
Yeah, it could. The question about whether something is generic, excuse me, is a question of fact. So a lot of times it's difficult. The more you can show that it's unique, the more you can show that you've used it in commerce, and that customers are actually associating it with you, the better. Well, you probably shouldn't tell me the name again, but so you look at it specifically, and you start looking at whether consumers are actually associating it with you, as to whether it's attained secondary meaning. If we really get into a big argument about secondary meaning, in terms of whether it's moved from generic, most courts want to see surveys, consumer surveys. When you get into consumer surveys, it's very, very expensive. But you can usually make the case, especially in a startup company, that you've attained some level of consumer recognition. What you told me, I don't know if that would be generic or not. I have to think about that. But any other questions about what I kind of rambled about what trademarks are? Basic understanding of what a trademark is? Yeah. Okay. Now, why do we want to protect trademarks? First of all, let's go to a fundamental, question.
I was going to answer.
You're going to, oh yeah, good. All right, tell me why to protect trademarks then.
I protect
I was thinking it was rhetorical, but no, I'm glad to have somebody answer. Please.
Why do we want to protect?
Why do you want to protect trademarks?
I think you already touched on it a little bit that consumers are going to get confused. They expect a certain thing out of out of a product from Starbucks or McDonald's. They expect it to taste a certain way and to be a certain quality, whether it's high quality or not. And if you another company that's not McDonald's or Starbucks uses that trademark, those customers are going to be deceived. I think you already touched on that a little bit.
Right. That's great. And it actually touches on a lot of what I want to talk about, which is you can come at this from a lot of different angles, right? You can come at it from the consumer's angle of when I buy a cup of Starbucks and it says Starbucks on it, it should come from Starbucks. When I buy a Heineken beer, it should be from Heineken. So from a consumer protection standpoint, you get to it from that angle of there's some quality, whether it's good or bad, that you begin expecting from something that bears a trademark of a company. But you also touched on the fact that from the company standpoint, involved in your trademark is goodwill. And in any business transactions, any business, the goodwill is a big part of that business, hopefully, unless it's bad will. But the goodwill can be a lot of what the business has. A lot of the business's assets can be tied up in its goodwill, the consumer's feeling about that company. Is Starbucks coffee better than Uptown Coffee? I don't know, but Starbucks has a pretty wide market share because of their trademarks. And things like that. Maybe Uptown Coffee's begun to gather that in Oxford as well. But the trademarks are important because consumers do associate it with the business, and they do associate the goodwill with that business as well. And so we get at it from a couple of different angles. We need to protect the business, and in order to protect the business, we need to protect the products of that business, and the trademarks are some of those products. But we also have to protect the consumers from confusion. So it's kind of a two-sided thing. Now, from the business's standpoint, also, it's a multi-sided thing. You need to protect the business. You need to protect the business's goodwill. What if I started selling coffee under Starbucks label and it was really awful? Well, at some point, the goodwill that Starbucks has built up, everybody's going to say, gosh, this is horrible. But it's from Starbucks, and it's going to start eroding that goodwill. So as somebody that's representing businesses, of course, I need to be adamant, if I'm their attorney, about protecting that. Another aspect of trademarks, though, is, as we've talked about the different levels of trademarks and the different categories of trademarks, one of the aspects of it is that it can become generic. If somebody else begins using it, it becomes generic. The other thing is if other people begin using it and labeling their products with my trademarks, I can lose my rights in those trademarks, because when I go to enforce it in court, a court may say, wow, you haven't protected it, and there are 8 people out there all operating with your name, Will's Apples or whatever, and it's computers. There are 8 people. The consumers have no idea where this product is coming from. And so I can lose my distinctiveness in my trademark. And if I do that, I'm losing an asset in the trademark itself. And you can think about that from perspective, from a startup, that's not as big a deal. But from a company with well-established trademarks, Coca-Cola may not really care if some student organization prints a t-shirt with Coca-Cola on there, but they have to care, because if they don't protect their trademarks, it erodes the rights that they have in those trademarks. I always equate it with universities to leaving the keys in the van. You can't leave the keys in the van. Just like you can't leave the keys in the university van, you can't not protect the trademarks. And so you'll see a lot of times, and maybe I see, maybe nobody else sees, but I see companies getting some bad press because they're protecting their trademarks against some little mom and pop shop. The reason they're doing that is not necessarily that they care about the small amount of product that company is producing, that the little company is producing, but it's because it's a bigger issue here, which is protecting the trademarks in the business. Yeah, question?
How would you describe the relationship between a logo, the business logo, and a business trademark? For example, those of us who remember, Pepsi has changed its logo numerous times even in the last 15 years.
Sure.
Coke not so much, but they changed certain things.
Yeah.
But obviously they don't change the trade dress, and you still kind of recognize that if you see a circle with red top, blue bottom, and the white thing in the middle, it's Pepsi.
Right.
So, but would you say that? How would you describe that relationship? Because obviously, if you see, and it's not going to be popular around here, but an orange Longhorn logo, you know what it is.
Right.
Texas could change it, and they have, but you know what it is.
Right. Well, and it's a good question. When you see changing labels and changing designs and stuff, those are new trademarks. Now they may be playing off of old trademarks, so that when Pepsi changes, or the old Coke bottle, which is such a distinctive design that you could put almost any label on that bottle and people are going to know it's a Coke bottle. But what they're doing is they're using different trademarks. Every time there's a new design, there's probably a new trademark involved. Those trademarks may trade on the other trademarks as well, on the older trademarks, and pull in that goodwill from the other trademarks, but they are effectively creating new trademarks. Now there is some room in trademark law for if I don't have it written up there anymore, but if my Coke that I wrote out, if somebody changes it just a little bit, there's some room to say, well, it's the heart of the original design. It's not really a new design. But when you see Pepsi and some other companies, I don't know about Pepsi specifically, but when you see companies going through different levels of designs and stuff and new designs, often they are new trademarks. They're clearly using colors, like if it was University of Texas, I'm looking at your shirt because it's kind of burnt orange. If it was, and that's a very strong color identifier with the University of Texas. Now around here, it might get confused with the bright orange north of us for University of Tennessee, but at least in Texas and those places, that color is very strong. And so whatever mark they put on there is also an identifier. So different symbols could also be different marks as well. All right, so we protect it to protect the goodwill. The goodwill can be diminished by lesser products being used with the trademark. We also protect it just to protect the trademark, because we can lose our rights in the trademark. The third reason we protect it is because some businesses, the business model is actually to market the trademarks, right? And so Coca-Cola, some larger companies make money on the product they're selling, but they also sell other products labeled with that mark as well. I think of Ole Miss shirts that Nike manufactures. That is a business model. The university makes some income from marketing their trademarks or shirts with their trademarks on them and things like that. So it is actually an asset that's sellable in some ways like that as well. How do we do that in trademark law? Because I said that if Nike is manufacturing a shirt for University X, why is that not somebody else using the trademark? Trademark law actually provides us a very tailored exception to someone else using your marks, eroding it, which requires that we license it, and it requires that we stay away from something called a naked license. A naked license is me giving you the right to produce a trademark shirt or something with use my trademark without controlling the way you use it. So universities, companies that do allow people to license their trademarks and to use their trademarks have a licensing department, and a licensing department has to control exactly how that product is used. They have to control the goods and the quality of the goods and stuff that it's being used on. Yep, question.
Is that what happened when like a high school team uses the same logo as like a college or professional team?
When someone enforces that?
No, like do they have to get permission from like that school? I think there was a case a couple of recently, like Wisconsin maybe sued a high school or
Yeah.
district because they had that same W. And they, I don't know if they like asked
Right,
permission.
and I'm sure for Wisconsin it was a bit of a public relations issue. They don't like having to do that, but part of the issue is they're worried about their trademark being eroded by being used by someone else. I don't know if they licensed it to them in that instance. When you do see a license, that's typically the reason of the license. Is it's another revenue stream for one reason, but it's also to pull that. I think the trademark law considers the person that you license with a related party, and so it kind of pulls them under our umbrella of licensing and makes them one of us in terms of the trademark use. So I'm not familiar with the Wisconsin, but yeah.
But so is it just a common law where you can define, even like Southern Miss had an issue with Iowa because the Hawkeye and the Golden
Right.
Eagle were, but I mean one's, I think like the head was facing to the right on one, to the left on the other, and there were distinct differences, but yet I think Iowa won. I mean I think Iowa was winning.
Yeah, and I wasn't involved in that one. There was some dispute involving University of Southern Mississippi, and Iowa came in and argued that it was a use of their trademark. That would be a very similar thing. In that instance, the plaintiff in that case would have a real hard time licensing that to the defendant because they're not using it to identify the plaintiff's goods. They're using it to identify the defendant's goods. So it's a very different thing than just a license. They would have a hard time settling that case based on a license. They would have a difficult time licensing it unless they divided up territory or something like that. So those are kind of the reasons that we need to protect trademarks. And in an ongoing business, we protect them. We have to police them. and those kind of things. In fact, I was speaking with someone who works for a television network recently, and she said that that's what she does on Friday afternoons, is she looks for both copyright infringement and trademark infringement on the internet. She sits, and that's the time that she polices their marks and their copyrights. In terms of a checklist, when we're working with clients, because I've kind of stumbled through this, what do we do when a client comes in? Well, first of all, we worry about business entity and tax and all of that kind of business. But then I want to talk to them about the business name. I want to talk to them about products they're going to produce. I want to talk to them about logos. When we get it down to where they have logos and product names, I want to talk to them about registration. I want to think about registering the trademark or service mark. Registration costs a couple $100 per classification that we registered in. So registration can be as cheap as a couple $100, maybe $320. I can't remember the exact. It's $325-ish. We may register in a couple of different classes, like for use on identifying shirts, if it's a clothing company, and pants, to porcelain ware, to bottles for soft drinks. And so we may need to register in a couple of different classes, but I want to discuss that with them. There are two different ways we can file a registration. We can file a use in commerce, which means we're currently using the trademark I erased my thing again. That we're currently using the trademark in commerce. Did y'all notice when I wrote the Coke, I put a TM after it? That means it's a trademark. That means I claim a trademark. Sometimes you'll see the R. If you look on your Coke bottles and stuff, somewhere behind the Coke, there'll be an R. The R means I've registered it. The TM does not make a claim of registration. There's actually a penalty for claiming a registration when there's not a registration. So the first thing I'm going to say is, okay, when you start using, if it's a service mark for your business and you've got a logo, put it on business cards. Let's make sure we have a TM after it. Or an SM if it's a service mark, if it's on business cards particularly. Let's go ahead and make sure that we're marking it for those purposes, because when we do want to register it with the Patent and Trademark Office, it'll be nice to have that as proof that we've been using it and how we've been using it. Second way, though, that I can file a trademark application, I can file something called an intent to use application. Intent to use saves that date and time, the day I file it. It saves that as a priority date. So if somebody else comes in and registers it, tries to register the same mark, they're going to register after me. So it saves that date. So if it's in an area that's really competitive and they feel very strongly, but they don't have time to go ahead and use it in commerce before you do registration, you can do that. But that begins the clock ticking. And within a certain period of time, I then have to file an affidavit saying that I've used it in commerce and giving them samples. You can drag that out a couple of years. By drag it out, I mean you can pay additional fees and get extensions on that for a couple of years. But I like to, a lot of times you can't avoid filing an intent to use, but it does start that clock ticking. I was going to say I like to file use in commerce ones, and I do, because it does. It's kind of a final. We've thought it through. We've got it. We're ready to use. So that's the next thing I talk to them about. One problem when I file a registration, not a problem, but a potential problem, is that they can come up with conflicting marks. And I don't like surprises. So I want to know if there are any conflicting marks first. So when my client comes in and says, here are the trademarks I'm considering using, or when I say, let's talk about things that could be potential trademarks, I'm going to write them all down. First thing I'm going to do is I'm going to get on Google, and I'm going to Google the name. I'm going to see if anybody else is using it, if the way they're using it is similar to the way we're going to use it. Then I'm going to do a search with the Patent and Trademark Office online. I can get online and go through their database and see if anybody's registered a trademark with those words. Problem we get into with design marks is they're much more difficult. So I could actually register. I think I've lost my pen. I could actually register a design. I don't know what that is, but it's my trademark. It's a tree. That didn't really help, did it? That's my trademark. It's very difficult to register. Some people are really good at that. I'm not. You have to be able to describe it. And you can search by descriptions and stuff. So those are the two levels of searches that I would do in my office to begin looking for a client to see if anybody else has begun using it. A lot of clients will have already done a good bit of this. Doesn't mean I wouldn't do it as well. The third thing I can do, well, I can also search, in the state registrations. If I'm in Mississippi, I can search the state registrations. But the third thing I can do is I can actually pay to have a trademark search done. There are trademark search firms that do a much more thorough job than I can do. And they will send you a report that's usually about that thick with all the different potential trademarks or uses of the phrase or the slogan or the design that you've done. It usually costs between $500 and $1,000, so it's not cheap, but it's a very thorough search. And that's not a bad idea to go ahead and get that done as well. That begins helping my client for a couple of things. It begins the dialogue with me, with him, in discussing, let's start thinking about trademarks and how you're going to protect your trademarks. But also, you know, here are 14 other people using your trademark. It may not be that strong. Maybe we want to choose something else. And it can help begin in that process as well. So I like doing all of those things before you register, because if I do it after, first of all, I may lose my registration fee if I lose the registration, if I don't get the registration. So I like doing all these things. I don't like surprises. So that's another thing you can kind of get the ball rolling with the business. The other thing, because the final thing, and I'll see if y'all have questions, is again, these notices. They don't cost anything. That one does. Don't use that if you haven't registered. But these two things, these two symbols, really all they mean is that that you're claiming a trademark in something. So a client says, I don't want to do a search. I don't want to pay you a penny to do a search. I don't want to pay a search firm to do a search. I say, okay, at the very least, when you use your trademark or symbol or service mark, let's start putting a TM or SM behind it. So it puts people on notice that you're at least claiming a trademark or service mark. Same with copyrights. We can always write the little copyright symbol in the copyright notice. Doesn't cost anything at all. It may have some deterrent effect with other people that might want to use it. Puts people on notice that I'm claiming it as a trademark. So my best advice when you go out and you start practicing and you're doing business law and advising, if you're advising small clients like I mostly was, is to just begin the discussion with them. It's not a discussion that you have that I think it comes before discussions of choices of entity and that kind of stuff. I'm not that arrogant, but I do think it's one of the first discussions you have with them is, all right, let's talk about trademarks. It's very inexpensive to protect them. It's very easy to protect them. It's a lot easier to do all these things at the beginning of the business than later. And insignificant things that you don't think of, like a client gets 6,000 business cards printed up, 5,000 envelopes, 6,000 pieces of letterhead. All of that costs startup businesses, and a lot of them don't have money to go back and do it. And then when they've done it, turns out that's a service mark that's being used by another business. That's something that you can help with if you've had some of these initial discussions. Then as the business continues and you get into that, then you get into more enforcement and policing of trademarks and things. But initially, really the discussion, I think it's very helpful to have your lawyer involved in that discussion, if it's with an ad agency even, to looking at trademarks and considering them. Any questions? I'll take your questions. Yes, question.
This had me thinking the other day, because the speaker we had in class was talking about just putting a mark in like situations where you don't want it, and I was just kind of wondering, like, is the university or like who licensed out their stuff to Playboy whenever they make? Does Ole Miss do it? I mean, if one of them did it and none of the other SEC schools did it, it's going to make you look bad.
So give an example, like Playboy. Yeah. There are some, anytime something like that happens, the First Amendment collides with trademark law or copyright law. There are some exceptions where you can use a trademark. I can refer to Coca-Cola as a product identifier. I can't use it to advertise my own services, but under the trademark fair use doctrine, I can use it to refer to their product. I can use Coca-Cola in advertising my product by saying my product's better than Coca-Cola. Comparative advertising. I don't know about the specific instances of a magazine using a mark. It depends totally on how they're using it. If they're using it in one of those ways to actually identify my product and not to sell their product and not to confuse and not to dilute or tarnish my mark, then it might be considered part of the trademark fair use doctrine. Comparative advertising is really the easiest example of that I can give. You see Coke and Pepsi all the time, and it says, Pepsi, a third better tasting, or whatever it says. It's comparative advertising. They're actually using the Coke mark to sell their product. So there are instances when you can use somebody else's trademark like that. They're very limited, but where you can use somebody else's trademark in order to identify their product for those reasons. So that's kind of a cop-out. I didn't really answer your question about the magazine, because it depends is the answer, and they're probably pretty careful about it.
So do you specifically license out Ole Miss's?
I do not. We have a licensing department. Most universities have licensing departments. Ole Miss has a licensing department here on campus, but the University of Mississippi also uses a company called Collegiate Licensing Company, which is CLC. I was trying to think. There's some CLC person's going to be on campus, I think. Anyway, maybe we can get them as a speaker. But they use a licensing company. So if you want to license Ole Miss material, you know, for use on a cup or whatever, you would go through collegiate licensing. You'd say, I'm going to produce 5,000 Dixie cups. Probably wouldn't say Dixie cups. 5,000 plastic cups. And I'd like to use the script Ole Miss, and they would give you a price. They would get it approved by the school, and then they give you a price. Some schools do that all in-house. Some of it's through their attorneys' offices. A lot of schools do that with collegiate licensing is really the biggest of those companies. There are others, but collegiate licensing is certainly a big one. Questions? Yes?
Like the University of Georgia and the Green Bay Packers have the exact same G, like exactly the same. So can two different entities just like agree to use the same one but both trademark it?
Yeah, I don't know about the specific example of Green Bay, and I hadn't thought about it till right now. They are kind of similar, aren't they?
Yeah.
I'm sorry?
The trade dress isn't the same.
The trade dress is different. The colors and things are different. The answer is it depends, of course. Yeah, there was the great example of that is the little guy who owns a hamburger store, and I don't know if it's a real example, but the little guy that owns a hamburger shop in Southern California, his name is Tom McDonald. And then McDonald's comes in and trademarks the mark. Can they force him out of that market? Typically, prior users can maintain in their area the use of that trademark. It may have been a prior user at Georgia or Green Bay may have been the prior user, and they may have limited them. It's difficult to limit either of those teams, frankly, by geographic territory. They may have worked it out. I don't know the example on that. Questions? Yes?
You talked earlier about how Kleenex and Xerox have kind of moved from the fanciful to the generic.
Yep.
I think Google's in.
Those companies actually resurrected themselves. They did a very nice campaign in the 80s and 90s, and it's kind of a lesson for you if you're ever the attorney in that position of trying to resurrect trademarks. They did a very good job of beginning to police their trademarks. It involved, working with network news people to get them to quit referring to Xeroxing something or grabbing a Kleenex instead of a Johnson & Johnson brand facial tissue. And so there's a lot of education that goes on, and those companies I think did a very good job of resurrecting those things. Google, I don't know, maybe it's a real danger, because if you have a real fanciful mark, and I'm not going to use Google as an example, but say I make up one, ZBT is going to be my mark, and it's in a circle like those little things people put on their cars. And it's my computer company or something. It's absolute nonsense. The word means absolutely nothing. So it would start off certainly as a fanciful mark. But then if everybody starts saying, gosh, I got to get a new ZBT, I may do such a good marketing job, and it's a real problem. It's a real, it's not an honor. But I may do such a good marketing job that people quit calling these things computers. And they start calling them ZBTs. Well, that's great for my ad agency, because my ad agency says, we've done such a good job that we've saturated the market. Well, the problem as the trademark attorney is it then becomes generic, and I may lose the ability to control it. So it's a real pickle. I mean, you may, by success of your marketing efforts, actually lose your trademark rights in something. It's a problem. I don't know about Google if that's... Certainly people tend to use Google as a verb now, but the Google, the folks who own Google would dispute that and would fight that, I think. Other questions? All right, well, thank y'all for coming.